Subcommittee for Indigenous Peoples of the United States will now come to order. The subcommittee is meeting today to hear testimony on H.R. 3160, Blackwater Trading Post Land Transfer Act, and S-46, Klamath Tribe Judgment Fund Repeal Act. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chair and the ranking minority member. This will allow us to hear from our witnesses sooner and help members keep to their schedules. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record if they are submitted to the clerk by 5 p.m. today or the close of the hearing, whichever comes first. Hearing no objection, so ordered. Good morning, and thank you to our witnesses for traveling here to testify at this hearing, especially Governor Lewis from the Gila River Indian Community in Arizona. Today, we will be examining two pieces of legislation. H.R. 3160, Blackwater Trading Post Land Transfer Act, authorizes the United States to place 55 acres of historically and culturally significant land located in Pinal County, Arizona, into the trust on behalf of the Gila River Indian Community. The land on which the trading post sits is surrounded on three sides with the community's reservation, with the frontage road of SR 287 bordering the fourth side. The Blackwater Trading Post most likely began operations selling and buying goods with the community shortly after the highway was built in 1926. The trading post was purchased by the Gila River Indian Community in 2010. Among the contents of the building, which include a grocery store, a tack shop, a deli, and a store, is a museum collection of over 1,000 cultural items, including 126 Akamil Odom baskets, sorry if I killed that. Due to the community's purchase of the land, these artifacts are now safely held with the community's Heritage Center. Though the community is unsure whether it will reopen the Blackwater Trading Post, they are eager to take the land into trust to ensure that it's preserved as an important piece of community history. Our other bill, the Klamath Tribe Judgment Fund Repeal Act, provides greater flexibility for the Klamath Tribes of Oregon to access and use judgment fund monies they were awarded following successful litigation against the United States. Like many other tribes, the Klamath tribes were terminated by Congress in the 1950s during the shameful termination era. As a result, their lands and other tribal properties were monetized and distributed to individual members of the tribes. The Termination Act also required that tribes submit to the Secretary of Interior a final roll of tribal members. The tribes complied, submitted a list consisting of 2,133 individuals referred to as the 1954 roll. At the time of their termination, the Klamath tribe also had pending lawsuits before the Indian Claims Commission seeking compensation for the mismanagement of tribal assets. After the court made its judgment in the tribe's favor, Congress passed the Klamath Tribe Judgment Fund Act in 1965 to enact the decision, directing the Secretary of the Interior to make per capita distributions to all living individuals listed in the 1954 roll or to their heirs. However, limiting compensation to individuals listed on this outdated roll has had unintended and adverse consequences. In 1986, the Klamath Tribe's federal trust relationship with the United States was restored, which reinitiated the enrollment of tribal members. Despite this, the language that exists in the Judgment Fund Act still prevents any distribution of funds for the benefit of the tribes or any members enrolled after 1954. The Klamath Tribe Judgment Fund essentially robs the tribe of the ability to determine how best to allocate the compensation they are owed. S-46 repeals the Klamath Tribe Judgment Fund and Act and supports the tribe's ability to exercise its sovereign authority and discretion over tribal funds. I look forward to hearing all of the testimony on these bills, and I would like now to recognize the ranking member for any opening remarks.
Thank you, Mr. Chairman. On these two bills, I'm actually very interested in the first one because it's adjacent to California, and I'm always interested in museums, particularly Native American or Indigenous people museums. I'm a historian. So I don't have any problems with that, and I actually don't have much of a problem with the second bill. But where is the Department of Interior? I wanted to ask whatever representative of the Department of Interior was represented here what the process were, how they tried to locate these people so that due process was followed. And we don't, not that I'm an attorney, but somebody in the future might say we got left out of the process on this rush to judgment. I don't know. I just wish we had somebody from the Department of Interior, their They're still located in Washington. We didn't relocate them to Denver, did we? I'm being facetious, but
Don't give me any ideas.
I would have appreciated for my questions and, quite frankly, my edification, so I could ask certain questions. So I've done a lot with Native American stuff in California. It was a very painful process when we did this a number of years ago on Native American parenting, and some of the laws that were on the books that were really, really anti-Indian, and from trying to get through that was very painful, but we had a bipartisan bill that finally got passed, and I thought it was a game changer. But so I don't have any problems with the exception. I would prefer to have asked Department of the Interior, particularly about the process and why this is, if it is replicated in other tribe settlements. Thank you.
Thank you, Representative Cook. Now I'd like to transition to our panel witnesses for today. Let me remind the witnesses that under our committee rules, oral statements are limited to 5 minutes, but you may submit a longer statement for the record if you choose. When you begin, the lights on the witness table will turn green. After 4 minutes, the yellow light will come on. Your time will expire when the red light comes on, and I will ask you to please wrap up your statement. I will also allow the entire panel to testify before we question the witnesses. The chair now recognizes the Honorable Stephen Rowe Lewis, the Governor of the Gila River Indian Community.
Good morning, Chairman Gallego, Ranking Member Cook, and members of the subcommittee. I am Stephen Rowe Lewis, the Governor of the Gila River Indian Community. Again, thank you for the opportunity to provide testimony on behalf of the Gila River Indian Community in support of H.R. 3160, the Blackwater Trading Post Land Transfer Act. H.R. 3160 is a non-controversial piece of legislation that authorizes the United States to place into trust 55.3 acres of land located contiguous to but outside of the exterior boundaries of the community's reservation. This land is commonly referred to as the Blackwater Trading Post land. Normally, such trust acquisitions would go through the administrative process at the Department of Interior. Unlike many other tribes, the community is in a unique position because of the community's Indian water rights settlement that Congress passed in 2004. In our water settlement legislation, there is a provision that explicitly requires congressional legislation if the community wants to place land outside of the exterior boundaries of the reservation into trust status. Given this statutory requirement and the location of the land, H.R. 3160 is required to place the Blackwater Trading Post land into trust status for the benefit of the Gila River Indian community. Let me give you a little bit of a history about the Blackwater Trading Post land and why it is so important to the community to place this land into trust status. Dating back to 1930, the Blackwater Trading Post was originally owned and operated by the Ellis family, who were non-community members. The trading post was within walking distance to our community members living in District 1 of the reservation. Community members would often trade basketry, pottery, and other items for basic groceries and other goods when they were unable to pay with cash. As a result, the trading post obtained a significant number of Akimel and Peeposh cultural items. In 2010, the Ellis family sold the Blackwater Trading Post to the community, which at that time included a grocery store, tack shop, deli, store, and museum. The community immediately performed an inventory of the Trading Post's museum collection and determined that the museum collection contained more than 1,000 items, including 126 Akimo baskets. Because the community was able to purchase a Blackwater Trading Post and all of the items within the museum, the community placed this collection of artifacts in the community's Hugum Heritage Center to preserve them. The community closed the trading post following the sale and inventory in 2010. And at that time, the community does not have any specific plans for the land. While the community has no plans to develop the lands, the legislation provides an explicit prohibition on gaming on the land. In conclusion, as I mentioned earlier in my testimony, because of our water settlement, we need federal legislation to place the Blackwater Trading Post land into trust status. This legislation is non-controversial, bipartisan piece of legislation that is absolutely critical for my people on the Gila River Indian community to be able to place this land into trust status and become part of the reservation, and more importantly, part of our homelands for our future generations. The community thanks this subcommittee for holding a hearing on this important piece of legislation, and we look forward to working with you to pass this bill through Congress. Thank you again for allowing me to testify. I'm happy to answer any questions you may have.
Thank you, Governor. And now the chair recognizes Mr. Donald Wharton, a senior attorney for the Native American Rights Fund.
Thank you, Chairman Gallego and Ranking Member Cook. I appreciate the opportunity to testify today on behalf of the Klamath Tribes in support of the Klamath Tribes Judgment Fund Repeal Act. As the excellent summary you gave, Chairman Gallego, the essence of this bill is to restore to the tribes their sovereign authority over their own funds. And to be clear, these monies in these trust accounts are the tribes' funds. They do not belong to any individuals of the tribes. To go directly to Ranking Member Cook's concern about due process, the Interior Department did address an earlier version of this bill that did not get introduced into the House. It passed the Senate, but never was brought up in the House. And their only concern at that time was whether or not the funds that are in these accounts would continue to be held in trust accounts. Because of litigation in the past that found liability on behalf of the department and the Treasury Department in the mismanagement of trust funds, they were very anxious to have this money distributed to the tribe and not have it continue in the trust accounts. That was the only concern raised by the Interior Department. So they don't really have much interest in this beyond that. And so their absence here today is not particularly remarkable. So I share that with you. It's in the record in the Senate if your staff could probably access that on the earlier legislation. The point of all of this is to say that the really disastrous results of the Termination Act that was adopted 65 years ago included this Judgment Fund Distribution Act. It's the last vestige of that termination era legislation still on the books. And it has the very unfortunate result of causing, if it is not repealed, any distribution of funds, first of all, to be seriously reduced by the cost of distribution, because the requirements of distribution to the 2,133 members and their heirs and legatees is a very involved process of identifying all of those individuals and would consume most of the money that's in the accounts just to administer the distribution. So that's the first and one of the more significant problems with it. The second one is the heirs and legatees at this point are largely, are significantly at least, represented by a lot of non-members and non-Indians. It does not go to the tribes and its members. And so it has a very inequitable and unfortunate result, one that was not intended necessarily at the time of termination, but of course at the time of termination, the purpose was to eradicate the tribe and its culture. And so clearly not a result that would be continue to be supported today. So the repeal of this particular piece of legislation would be the last vestige of that termination policy in the termination era, and something that, of course, the tribe strongly supports. Finally, the result would be that the tribe could then exercise its own sovereign authority over the distribution of those funds once they are distributed to the tribe, which the Interior Department asked to be part of the legislation, and it is included in the legislation, that after repeal of the act, the distribution would take place. Thank you very much again for the opportunity to testify, and I appreciate any other questions you may have.
Great. I thank the expert witnesses for their testimonies, reminding the members that Committee Rule 3D imposes a 5-minute limit on questions. The chairman will now recognize members for any questions they may wish to ask. I'll start by recognizing myself for 5 minutes. Governor Lewis, you mentioned during your testimony the community's connection to this land. Is it fair to say the community and your tribal members have had a close relationship to the trading post and the land? And could you elaborate on that a bit further?
Thank you, Chairman Gallego, for that question. Yes, given the location and proximity to the reservation, which is walking distance to District 1, our Blackwater village, community members have been going to the trading post for decades. And it's somewhere that our community members went to buy groceries and to socialize with other community members. In fact, if you look at the map of where the trading post is located, there is a small cutout of land where the trading post sits. You would assume that it was actually part of the reservation because it is surrounded on 3 sides by the reservation. So the community made it a priority to purchase the land from the Ellis family to preserve all of the cultural items that were located in their inventory. And it's now a time to place this land into trust for the community for the benefit of all of the Gila River Indian community members. Thank you, Chairman.
To follow up a question, does the tribe have plans to reopen the trading post? And if not, what does the tribe plan to do with the 55.3 acres in question?
Thank you for that question again, Chairman Gallego. The community has no plans as of yet, but definitely we will be reaching out to our community members for ideas and for ways that they want to see this land to be developed, in fact, in the future. The Community Council is definitely wanting to look at the highest and best way for this land to be preserved or developed for the future. But at this time, we have no plans.
Question for Mr. Warden. Can you elaborate on the tribe's role in the introduction of S46? How long has the tribe been working on this, and what other entities support this legislation?
I'm sorry, how many members are there in the tribe? Was that?
No. The question is, how long has the tribe been working on this, and what other entities support the legislation?
Oh, the tribe has been working on this. They provided testimony in the Senate for support for S46. They could not be here today personally because they already had an important meeting of the government of the tribe that they couldn't reschedule. So they asked me as their attorney. I've been representing the tribe, started working with them in 1973. So I've been working with the tribe for a long, long time and have a very good relationship with them. So they trusted me to come and offer this testimony today. But I'll be happy to get you a resolution of support for the legislation if that would be helpful to the committee.
No, we just kind of want to have a general sense, but I think we have that. Would you describe the Klamath Tribe Judgment Fund Act 1965 as a vehicle of the termination era legacy, and how has it impacted tribal sovereignty since then?
Well, it clearly was absolutely intended to be part of the Termination Act. Part of the problem in the early 60s was that funds appropriated, funds as a result of judgments against the United States were not automatically paid to the tribes who secured the judgments. They actually had to go through a hearing and an appropriation process in order to be paid. That was later remedied in the 1970s by a distribution act for all tribes. But specifically for the Klamaths, because of termination, they needed to have, or decided they would have, a specific distribution process. And that's when they adopted the Judgment Fund Act, was to provide for the distribution. And it's contained in several sections of what was then codified as 565 of 25 USC, and provides for how exactly the monies will be distributed. And they were to be distributed to the 2,133 members, and then, of course, to their heirs and legatees later, should any member pass away. And of course, that's where the problem arose, was when it became so fractionated, and not only do you have to find all of the individuals who are the legatees, you then have to figure out what their proportionate share of the distribution would be. So it's a fairly complicated process, but it absolutely was part of and intended to be part of the termination era process.
Thank you. Thank you. I now recognize Ranking Member Representative Cook.
Thank you, Mr. Chairman. You know, the first bill, as I said, I don't have any problems at all. I'm a little bit confused on what we're talking about, these funds. The remaining funds we're talking about now going to the tribe, instead of if any litigation or settlement claims popped up by tribal members or their descendants. Is that correct, Mr. Martin?
No, thank you for that question, Representative Cook. No, it is not. these funds have two sources. The first source was in 1958 when the tribes, because of the claims against the ICC, deposited with the Secretary of the Interior in trust $350,000 to pay for the cost of litigating those claims. Those monies have been replenished from claims. These are all tribal claims, not individual claims. These are claims that were brought by the Klamath tribes in the Indian Claims Commission, and they were under what's called Docket 100. The tribes that brought these claims had dockets for them under the Indian Claims Commission and later the Court of Federal Claims. The claims are all tribal claims that were then brought, judgment was then rendered, and under the Distribution Act, they could be paid to the tribes into the trust account that belonged to the tribe. Then a distribution process was adopted, and the distribution process then identified all of the individuals to whom the money would go. It was at that point that the individuals then had a right to accept the money. But until the time that a Distribution Act was actually adopted, these were all tribal funds.
The, you know, and I understand your explanation, and I appreciate you doing that. The problem I have here is maybe I wanted to, I shouldn't say this in the vernacular, but maybe I wanted to beat up on the Department of Interior for, you know, it kind of seems like this has been just a mess. And I understand that some of the original, this list, this master list or something, it goes back to the 1950s.
Yes, sir.
And I'm obviously a little bit perturbed that they're not here to explain the process on how that was cleansed in this day and age of the internet and informing people. You would think we could track down some of these people. Even I can track down some of my ancestors in Ireland that were not hung, I guess. So I'm not trying to take out my frustration on you. I just feel they should have been Department of Interior to answer some of these questions. And I, as I said, I apologize. Sometimes it just takes forever to cut through the red tape of any bureaucracy. I don't care what phrase you want to use, whether it's California, whether it's my hometown, blah, 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 blah. So anyway, I guess it is what it is. And just for the record, my concerns about this important hearing, if I understand it correctly, you came all the way from Denver, Colorado, but they couldn't come from down the street up here for this hearing. And I hope your flight was okay, because sometimes the weather in Denver is not very nice. I don't have any further questions.
If I could briefly, Congressman, I would never disagree with you that the Interior has messed up Indian affairs. That would not be my purpose in any way.
Is that a facetious remark, Counselor? Or
No, I mean that quite sincerely. So it's, but to be clear about this process, there isn't any point at this time to identify who the distribution list would be, because there isn't any distribution to be had at this point. The monies are simply in these trust accounts, and they're being managed by the Interior Department for the tribe, not for the individuals. And so there would be no reason to identify who all these individuals are at this point unless there was a decision to do a distribution.
I think I get that.
Okay.
My problem is with the Department of Interior not being here, because I want to question how this is done, why it has been delayed for so long, or why this, now we're in, how many years of this going on and on and on and on. And you're right, there's probably the chances of that, but maybe I just wanted to, you know, voice my concerns so that if in the process, if it was slow and cumbersome and late and everything else, they would, you know, change their procedures and it might be a welcome outcome of this hearing that they missed. So that's all I have. Thank you.
Thank you, Ranking Member Cook. I want to thank our panels of expert witnesses for the insightful testimony and the members for their questions. The members of the committee may ask some additional questions for the witnesses and will ask you to respond to those in writing. Under Committee Rule 3.0, members of the committee must submit witness questions within 3 business days following the hearing, and the hearing record will be held open for 10 business days for these responses. If there's no further business, without objection, the committee stands adjourned.